This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Mr. Hibner, and on behalf of Judge Bennett and Judge McBrayer, we welcome counsel to this oral argument, which we are live streaming to fulfill our obligation to maintain open courts. We will conduct the hearing in the same manner as if we were together in the courtroom. Each of you has 15 minutes, and the appellant has reserved some of that time for rebuttal. Unless there are any announcements, I'm asking Mr. Hibner to call the case.
Kimberly Black versus City of Clarksville, Tennessee.
Mr. Dean, you have the floor.
May it please the court, Attorney Ben Dean of the Robertson County Bar. This is a Tennessee Disability Act case. To let the court know, may wonder why didn't client bring an ADA claim? This is a TDA claim. My client came to me after the 6-month EEOC period had ran, very close to the 1-year statute of limitations. All I was left with was this Tennessee Disability Act claim for my client. Proceeded to file it. The issues which are before the court are really sort of focusing on two elements of these TDA claims. The first one is whether my client was qualified for the position. This is what I came to find is I don't do a lot of employment law. These are very fact-intensive cases, and a lot of facts go into how somebody performs at work. What are they doing? Why were they let go? Or, all these circumstances. So there's a lot of facts in this case. The reason why I believe Judge Hicks ruled improperly in this case is because I believe there was and is a genuine issue of disputed fact be determined by a jury in this case. Number one, as to whether my client was a qualified employee. And the second issue is whether my client had an adverse action against her. And so I'll first address qualified for the position. The case that I provided the court in both trial court and this court that I think there's not a lot of case law out here on the TDA. I provided, number one, this Hostetler case, Sixth Circuit case. And one of the facts that's interesting in this case, this isn't a circumstance where my client ever came and said, I'm not doing my job. The facts are undisputed. Ms. Black was a very good employee. She did all of her duties. They were a very understaffed department. Despite that, she kept up with all of her work. One thing in this case that makes it what I believe such an egregious case is that they use, in this case, a medical inquiry form from the ADA, and that's a big part of their defense and why they claim she's not a qualified employee. They use an ADA medical inquiry form filled out by a rheumatologist. And so in this case, I'd submit to your honors the proof, which is before trial court and before this court, to determine that contrast that medical statement, which if you read it, you could question whether my client, there's some things that how was she even doing her job if you read Dr. Desai's medical inquiry form. But looking at that, and then you got to contrast that, what was her actual job performance and how was she doing and what type of employee was she? And the evidence is undisputed from her supervisors and managers. She was a great employee. Her supervisor, when I asked him in his depositions in the record, what did you think when they came and told you they let Miss Black go? And he said, I was shocked. This is a case where they didn't do, and this isn't an accommodation claim. This is an intentional discrimination type claim and under that regimen. But this act doesn't provide my client with any right to accommodation. But they want to use this medical inquiry form and say, and Judge Hicks put in his opinion, that he said that doomed my client. The statements which were made by the doctor in the medical inquiry statement. One issue of fact within that is if you look at that medical inquiry form, they want to characterize it as medical restrictions that the employer does. If you'll read the form and look at the undisputed facts, they're not medical restrictions. And there's a factual issue. Looking at all these facts, how good of an employee my client was, there's a genuine issue of fact whether she was a qualified employee. Looking at that Hostetler case, well, I think it's so important that the court look at that. That's the case where they say, if these facts which are presented in that case, that an employee does such a good job, they're a great employee, they do all their duties, that is enough that you could grant summary judgment to the plaintiff that they.
Why aren't the doctor's statements medical restrictions?
They don't say medical restrictions. They do say limitations. And I would submit that those are two very different things. Looking at our concept of workers' comp, if you're placed on medical restrictions from your doctor, that is something which you shouldn't do. Limitations are things maybe things you can't do. I think there's a very big difference, and that's not really, is there medical proof in the record to really lay out, well, what are the differences in those two? No. But I don't think that
I'm not sure I understand the distinction you're trying to make between restrictions and limitations. Could you go through that again, please?
For
And
example-
didn't the doctor say that repeated hand use was a interfering with her job performance?
I don't believe he said that in his actual statement. And if you look at her actual job performance, that's the other undisputed facts are she met all the performance guidelines. The head of gas and water says she came to me and asked, was I meeting the standards? And there's only two things, accuracy and quantity of meters. She met the volume and she met accuracy. She was a great employee. She just applied for ADA accommodation and they brought her into a room and terminated her. And they rely upon that doctor's statement to have done that. But what I would submit to the court, looking at, was she a qualified employee? That statement is not the end all be all. And that's in the Hostetler case. That's what they use those words. That medical evidence isn't the end all be all. You have to look at the whole picture. And in that case, they reversed the trial court and sent it back and said that's a genuine issue of fact. As far as the restrictions, limitations, I want to address that. If someone's under actual medical restrictions, in the art of the term that's used in our workers' comp law, that means the doctor said do not do, they can't do these things due to an injury or illness. I would submit to your honors that ADA accommodation form that the doctor filled out. This is for people who are seeking ADA accommodation. It doesn't say my client shall not and medically cannot do these things. And I don't think that the employer, in this case, we've weaponized the ADA inquiry form for an employee. If this court upholds this decision, in every case where the employer's got an ADA medical form, that someone who's going to try to get under protection of law accommodation, it's being permitted to be weaponized to use to terminate them. And I think that in and of itself is against the public policy of our state, and it chills people actually seeking ADA accommodation. My client, they could have just as easily said, ma'am, we can't accommodate you. And she had to make an election. Do I continue to work at this job or not? And instead, they didn't do that. They didn't talk with any of her supervisors. They brought her into a meeting, and there's issues of fact about who made the decision and why they made the decision. That we got different stories about who actually made the call. They gave differing testimony as to City Hall or the gas department. But regardless, they brought her in the meeting and said, you don't have a job anymore. And this will segue me into the second part of the case. What happened at this April 11th, 2017 meeting and the adverse employment actions? In this particular case, they want to say, we subsequently procured a resignation from my client approximately, I believe, let me make sure, approximately 3 or 4 days after this April 11th meeting. At the April 11th meeting, my client is brought in and said, we're taking you off. You don't have your meter reader truck. Go report to City Hall. At that point, their position in this is, well, she really wasn't terminated that day. And they want to use the later resignation, which they procured, to nullify their prior adverse employment actions they took days and days before. Looking at that timeline, they had the April 11th meeting. They decide approximately, believe on the 14th is when they actually get the resignation letter signed by her. 1 day prior to that, they had already decided my client's last day of work on payroll, when that would be, prior to them obtaining a resignation letter.
Weren't they trying to find another job for her in some other department?
They claimed that they were.
Well, did they or didn't they? Did they try?
The proof is that they just say there wasn't any other.
So is that part of the problem? Had they found her another job, would she have taken it?
I mean, I don't know that we can speculate on whether she would or wouldn't have. I think that would be a lot of other facts that we would have
If they had just
assumptions
gone
about.
ahead and fired her because she didn't, the doctor said she couldn't do the job and they hadn't tried to find her another job, would this be any different?
If this doctor said she couldn't do this job and had given them other than this ADA medical form had given them some actual restrictions of a medical doctor that said she cannot do these, and she had asserted herself, I'm not doing these things, they could have terminated her on the spot. That never happened though.
Okay.
The other factor, looking at the adverse employment actions, also at the qualifications, there's another case I've cited. I apologize, I don't have it right in front of me. It says you're to look at the time of the decisions made. They also want to bring in many other things that occurred after that. And other than that medical inquiry form that the doctor, that's all that they've got. These other things are after that time, and under the Sixth Circuit law, you can't consider that.
All right. Thank you, Mr. Dean. We'll hear from you on rebuttal. Mr. Lonergan.
Yes, sir. Good afternoon, gentlemen. Matthew Lonergan from Bradley for the city of Clarksville. The issues before this court are very clearly laid out, and I don't think there could be a more fundamental difference between position of Ms. Black and what she wants the law to be versus the city's position, what the law actually is. And in order to have a successful claim under the TDA, Ms. Black would have to show she was qualified for the position, that she had a disability, and she suffered an adverse action. There's no dispute that she had a disability. So we're left with the question of, was she qualified for continued employment as a meter reader, given her disability and the limitations imposed upon her by her doctor? Okay, and I think that's a very important fact. Her doctor imposed these limitations. The job description is before the court. It requires repetitive motion, grasping, reaching, lifting, pulling, various load capacities, up to 50 pounds occasionally, up to 20 pounds frequently, and up to 10 pounds constantly. Ms. Black was part of the time out in the open elements, using a metal hook to pick up a water meter lid and constantly reading meters all day long. And she testified that the workload got increasingly difficult when prior to open positions were never filled. And I think that's one of the key things that's before the court is this isn't something that the city of Clarksville did contrary to the characterization, trying to find an issue to rid Ms. Black from its role of employment. She came to the Human Resources Department in December of 2016, explaining that she suffered from rheumatoid arthritis and that she was suffering increased pain and difficulty in performing the duties of her job. We don't dispute that the performance statistics up to that point in time indicated she was a satisfactory, if not a good employee. That's not a dispute. But what she clearly did was she started the process to say, I need another job. And she repeated to Denise Johnson, the HR person, mainly communication by email, saying, I need another job. I can't do this one anymore. It's constant, my pain, the swelling. I come home at night and I go to bed. And that starts the process. And the secondary part of that process is that once Ms. Black fills out the reasonable accommodation form, that form then goes with the job description to her doctor, Dr. Desai, not the city's doctor, her doctor, who'd been treating her for over 10 years for the rheumatoid arthritis. And she meets with him and she explains what she does. And the doctor creates the medical inquiry statement form that's at the heart of this case. And it comes back. And I think the distinction, which is between a limitation and a restriction, is much to do about nothing, because what the form says is she cannot do the job, the essential functions of a meter reader. And he says, cannot do repeated activity, like using both hand joints in cold weather, like reading meters, cannot do repeated activity due to the arthritis, like washing dishes or her car. He says the major life activities affected include lifting at work, walking, using both hands. He identifies limitations on her job performance and says repeated hand joint use at work, mainly reading meters and lifting lids, excessive walking due to feet deformity. These are all limitations that he identifies. And he says limitations that interfere with her job functions are repeated hand joint use and increasing her pain and swelling. Now, the TDA makes very clear with the cases that have applied it, that if an employer takes an adverse action against an employee because of their disability, there is no unlawful discrimination if that employee's disability to some degree prevents or impairs the employee performing the duties required by the employment sought, or impairs the performance of the work involved. And we would submit that both Ms. Black's reasonable accommodation form and Dr. Tsai's statement clearly set forth to some degree impairments on her performance. And contrary to the position asserted, Dr. Tsai's statement is a prohibition. It is entirely possible, and the law envisions that someone can satisfactorily perform their job over a period of time, but they reach a breaking point. Ms. Black reached that breaking point. She asked to be taken out of her job, and the doctor who she met with tells the city of Clarksville she cannot do it anymore. It's as straightforward as that, Your Honors. That's what the city acted upon. It has the right to do so. This is not a witch hunt looking to take Ms. Black out of her job. The testimony is that the city's practice was to abide by employees' doctor statements. It had every right to do so. And in the reasonable accommodation process, which is only a creature of the federal law, the ADA, it attempts to look at a situation that the employee's restrictions keep them from performing the essential functions of their job. And if they can't, and there's not another position open for which they're qualified, there is no continued employment. The TDA, this court has looked at previous decisions like this, and I think it's the Hilliard Dollar General case from 2019, and ruled that, in essence, when the employee comes forward and says, I need a reasonable accommodation to be moved to another job because I can't do the work anymore due to my disability, that ends the inquiry under the TDA. At the point that a reasonable accommodation is requested, it's an admission that the employee is no longer able to do their job, or in the multiple emails sent by Ms. Black in April, prior to this April 11th meeting. Yes, sir.
Once she comes to the department and makes that statement to the HR folks, is the department obligated to try and find her another job, either within the department or within the city government?
Judge Bennett, under the TDA, I would say they are not obligated to, because that would be considered a reasonable accommodation. Under the federal law, moving someone to an open job for which they're qualified is part of the reasonable accommodation process. The Tennessee legislature has not enacted one, but even without that situation, the testimony is that after she was pulled from her meter reader job on April 11th, she met with Ms. Johnson on the 13th of April, and she agreed in her testimony that they reviewed open jobs in the city and that she was not qualified for another position. So they satisfied any obligation that one would seek to impose upon them to look for another position.
So your position is they went above and beyond, and they sat down with her and went through all the open positions in the city government with her, and nothing worked.
That's right. And they did it in a two-step process. Before they met with her on the 11th of April, Pat Hickey, the manager of gas and water, testified that he had looked in the meeting in open positions in gas and water, and deemed that because of her lack of skill set and the medical limitations, she was not qualified for any opening in gas and water, put her on sick leave and sent her over to Ms. Johnson to meet with her to see what her options were. And they met and they looked at it, and Ms. Black agreed that they did not find anything open that she was qualified for. Okay. The city of Clarksville is completely within its rights to rely on the doctor's statement in making this decision. And there's two cases we cited on page 41 of our brief. One is Johnson versus the Cleveland City School District, and the other was Mathis versus the city of Red Bank. Both Sixth Circuit cases, 2011, 2016. The Johnson case says the doctor's restrictions must be taken at face value, and the employer was reasonable, indeed correct, to assume the employee could not perform a task that her doctors indicated she was incapable of safely performing. And so there's no reason to suggest that the doctor's note was a fraud or not valid. You take that in combination with the concerns expressed by Ms. Black to Ms. Johnson, She may have been qualified up until a point to do the job, but what the city is then processing is her information and the doctor's information and makes the decision that says, we're not going to ignore the doctor's statement. And
Well,
whether
you're not suggesting that there's any obligation on part of the city to go behind the doctor's statement.
Not at all.
They don't have to determine, is this not fraudulent or it's not based on a thorough examination.
Right.
You're entitled to take it at face value, right?
That's right. We don't have two competing doctors saying she can do it and one saying she cannot. To find a third opinion. There's some question from Ms. Black's perspective about whether or not the city should have relied on the doctor's statement when she previously had satisfactory performance and her supervisor said she was a good employee. And I would kindly suggest that that's not the equation. That's not the prong. She had the basic qualifications. The situation now is her circumstances changed. And that's why she was taken out of the position. They looked for another position. They didn't have one. And as a result, her status was on paid sick leave through April 28th of 2017. And that moves us to the resignation issue and whether or not she suffered an adverse action. And the city's position there is when she got pulled from reading meters on the 11th by Pat Hickey in that meeting, he told her she'd be on sick leave. And then he said, go see Denise Johnson and see what options are available. She met with Ms. Johnson on the 13th of April. They reviewed the situations. And later that afternoon, she sent an email back to Ms. Johnson in which she says, what I'm thinking it's going to come down to is that I'll have to go out on my own because it's taken too long for them to decide, is there an accommodation? So she knew there was a situation and she was likely to face an employment loss, her job. But that doesn't make her decision involuntary. There's four elements that are recognized in trying to determine whether or not a resignation is involuntary. And that is there an option or alternative to resignation? Did the employee understand the nature of her choice? Was she given a reasonable time to choose? And could the employee select the effective date of her resignation? Her emails grow an increasingly worried position that she says, I don't know how much longer I can do this. I don't know if I can do it another day. And in one of the emails where she talks about, should I just submit a letter resigning instead of them dismissing me? She says, Bob.
Excuse me. She sent an email to HR saying, I don't know if I can do this another day.
That is correct. There's multiple emails in the record that she's talking about the difficulty she's having. On April 2nd, I don't know how well I can form another job. I'm trying my best each day, but I'm hurting and it's getting more difficult each day. So when she meets with Ms. Johnson and has this discussion, she expresses concern that if her sick leave runs out on the 28th of April and she is then terminated, she has an elective surgery covered by May 1st and she won't have the insurance to cover it. So she asked, would the city extend my time to May so that I can be covered for the insurance for the month of May? And the city agrees to do that. And it gives an effective resignation date of May 2nd. So in this case, there was an alternative to resignation. She knew that if she couldn't find another job and her sick leave expired, she faced termination. Now, they're not two great options to choose between the potential let the facts fall where they may for a termination or resign, but that doesn't make the decision involuntary, and we cited cases to that effect. Second, she knew the nature of the choice before her. She had the understanding and the wherewithal to ask the city to move her resignation date from the 28th to May 1st or May 2nd so her insurance would continue. So she did that, and the city agreed to a resignation date. It is an unfortunate circumstance that that's what Ms. Black found her in, but it's not a circumstance that the city created or went looking for. Her condition put her in a position that she felt she was running out of time to be able to do her job, and she asked for another job. The city attempted to find her one. The city relied on the doctor's statements, and it made the decision that any other reasonable employer would do, which is, I'm not going to continue to expose someone to continued risk when their doctor says she cannot do her job anymore. That's not a reasonable business decision to make. and it's certainly not discriminatory to do what the city did in this situation, which was to remove her, and when she couldn't find another job, she agreed to resign. Her supervisor said, I need something so I can post your job. She signed the letter, and on that basis, her employment ended on May 2nd. Under the circumstances of this court, we believe the arguments and the briefing and the facts support the correctness of the trial court and Judge Hicks' decision, granting the city's motion for summary judgment. Thank you.
Thank you, Mr. Lonergan. Mr. Dean, your rebuttal.
First want to address looking at the big picture, this case and the decision that was made, and how would this play out in the future for other people's cases if this same, what they're saying here happens in other cases. And this isn't the only, everybody who's applied for accommodation who hasn't been accommodated has been let go. That was what the record is in the city of Clarksville. Looking at this and saying, okay, well, I want to use an analogous situation. This could be one of my secretary, your secretaries, and we're talking about arthritis here, pain of the joints. And your secretary goes and puts in an ADA accommodation because her hands are hurting. But she's working and she's doing her job. And she's not just doing her job, she's working really hard because your other secretary had retired. And that's like this one. She was working really hard. They were understaffed. They bring her in and she asked for accommodation, something that should be encouraged for people to do who are disabled. And I know there's no duty of accommodation under the TDA. They had the right to say, we're not accommodating you. They didn't have the right to come in and say, for somebody who's doing their job fully with their problems, they don't have a right to come in and say, we're terminating you because you applied for disability and your doctor says maybe you shouldn't be doing some of these things because of your conditions.
What about the emails that say, I just don't know how much longer I can go on and things like that?
Judge Bennett, after my client worked for approximately, I believe, 2 to 3 months after she made the application, fully worked and did her job. After she actually filed that, she was eager to get a decision about what they were going to do. And I do acknowledge she was desperately wanting an answer out of them.
If the city had kept her on, knowing what the doctor said about her RA, and not accommodated her, just kept her on, would the city be exposing itself to any sort of liability?
And this is exactly what, when I asked HR and I said, why, her almost xenophobic fear of lawsuits is why they think why they do what they do. But they look at this and instead of, they take this out and want to use this one doctor statement and they ignore her actual job performance. And they don't look at, if you look at the direct threat defense, which they say, we're not making a direct threat defense, which really they sort of thinly veiledly are by saying well, she's a risk to herself and others. The reason why they can't avail themselves of direct defense, a direct threat defense and safety is because they did not make, to do that, you have to actually go talk with their supervisors and engage in a meaningful discussion about what is their disabilities, how does it affect their work. They did not do that. They brought the woman into a meeting and terminated her. The people from HR, and there's a dispute. The Gas and Water says HR made the decision, but yet they never talked to her supervisor, anybody that she works with. And they want to say just this doctor statement. Relying on this, it nullifies how she worked, the fact that she worked for months after she applied for the disability, the fact that she was a great employee, that nullifies this one element, whether she's a qualified employee. And I would submit to your honor.
You're saying for future cases, then a city could just ignore cautions that a doctor gives about their employee or patient/employee because they're, for the time being, at least performing their job adequately. It seems like to me there's greater danger in the approach you're suggesting than what the city did here.
That would be the direct threat defense, which is a defense which they've not asserted and are not pleading, because you look at the case law, to assert that defense, you have to go and do an individualized inquiry and speak with their supervisor. You can't And the reason why these case laws require the employer to do that, to assert that, is because otherwise they could just make it up in every case. And so if you read those case law about the direct threat defense, that's thinly veiled sort of what they're saying. They can't rely on that because they didn't make that inquiry. They just terminated my client without actually speaking with her supervisors about her job, about how her disability actually affects her work. And like I said, they had an absolute right to say, we can't accommodate you. And that was her decision, whether it should have been her decision whether she was going to quit her job. And instead, they brought her into a meeting and they terminated her. She lost her job. And I know they want to say, well, they sent you to City Hall, but that was an adverse employment action on day one.
Thank you, Mr. Dean and Mr. Lonigan, for your arguments. We will take this matter under advisement.
Thank you.
Mr. Hibner.
This honorable court is now in recess until 3 p.m.
Counsel, you're free to exit the meeting.